Hi, I'm attorney Steve Reilly, and today we're going to talk about the 7 things that you really shouldn't have in your will. Well, the first one deals with your funeral arrangements, or what you want to ultimately have done with your body. The reason for that is, can you imagine the problem that would exist if after a funeral or a wake, or after the funeral's done, the mass happens and you're buried, that your loved ones go through your documents, find your last will and testament, and then the testament has language in it that says, I wanted to be cremated. That could be devastating to the people that you leave behind. So normally you don't want to have that kind of thing in a will. Well, in Connecticut, we do have this thing called a burial agent appointment, where you can actually instruct somebody to be your agent and actually set forth your wishes of how you want your remains to be dealt with. Otherwise, if you put it in a will, it could be discovered too late what your actual desires were. And let your loved ones know what your intentions are. Second would be organ donations. You could do that by way of your driver's license. Again, if you put that in your will, it may be a situation where it's too late to do anything about your wishes when somebody looks at the will after you've been buried or cremated. The third thing is designating in your will who gets your IRAs. The reason for that is there are some things that are just outside your will. And they're outside of it because you've already got a contract with someone else directing that entity to pay a specific person you name. So in an IRA, when you're going to the bank and doing one of those, or your investment counselor to get one of them done, you're ended up naming a beneficiary and perhaps some contingent beneficiaries. So you could end up in a situation where you had the IRA many years ago set up. So you have a very old designation in it saying who you wanted to get your IRAs, only to later have, if it's in your will, you now could be very well naming somebody absolutely different, not knowing that the will itself is not going to trump, so to speak, the IRA itself. The IRA's designations will win out. Now, you can have certain trusts, for example, or IRA trusts, or certain trusts where you make the trust the beneficiary of your IRA, and then you can name beneficiaries in that sense. But you really don't want to put them in your will. The fourth thing are life support decisions. In other words, what is commonly seen in a living will or a healthcare agent appointment. You don't want to do that, again, for the reasons why you don't want to deal with organ donations in your will, because, again, the will could simply be seen subsequent to the time after you're buried or cremated. So life support decisions are commonly put in a separate document. In Connecticut, they combine both what are commonly termed as a living will and a healthcare agent appointment document, and the appointment of a conservator in the case that you might need one. That is done now, it can be done now in Connecticut in one document together. The statutory document that exists in Connecticut is all 3 of those things combined. So you could do that in a separate document. You could name who you want to make life support decisions for you in the event that you cannot. And an important thing to remember about those healthcare agent appointments, and I get questioned about them all the time, is that they are, by statute, orally revocable. So it doesn't mean that if you signed a healthcare agent appointment, appointing somebody to make healthcare decisions for you, that if you were in a hospital and a doctor asked you whether or not you wanted a certain operation, and you said, go to it, doc, I want that operation, only to have somebody else say, no, I got this healthcare agent document, and I'm telling you, doc, do not do the operation. You could simply say, the document, I revoke it, and therefore I want the doctor to do what I want them to do. Medical people will always do what you want them to do, as long as you are capable to do it. The benefit of those healthcare agent appointments are when you are not able to do it. But in any event, you don't want those in your will. The fifth one is assets that are already in your trust. In other words, in order to have an effective living trust or revocable living trust or any kind of trust, you have to do what's called fund the trust or put an asset into the trust. So for example, if you were going to have real estate in your revocable living trust or irrevocable living trust, if that's the case, in either case, you would be naming your real estate into that trust normally by way of a quitclaim deed. You would deed the asset into the trust. Well, naturally, if it's already in the trust and you've got it going by way of the terms of that trust, it's not going to make any difference what you do in your will. Number 6. Similarly to number 5, if you have assets already titled in an LLC or a limited liability company, or for that matter, a corporation, you don't want to name those assets in your will because it's already owned by another legal entity, which is not you. What you own in an LLC or in a corporation, for example, in an LLC, it's called a membership share that you own. So if you were willing anything to someone, it would be you're actually willing the membership share. In a corporation, you would own stock. Just like if you own stock in a small corporation or a big corporation, it doesn't matter. The stock is what you own. You don't own the company. So you don't own the individual assets that might be in that company. Number 7, life insurance and annuities. The reason you don't want those is very similar to when we talked about IRAs, that you designated your IRA to go to a specific individual. In other words, if you've got life insurance and you've named your son in that is the beneficiary, that if you had it in your will that you wanted it to go to your spouse or your daughter or your other son, the will is not going to take precedent. The life insurance company will simply pay who you directed them to pay. Now, you could name a life insurance policy's beneficiary to be your estate, but there's reasons why we don't want to do that, and that is because the life insurance would then get pulled back into your estate and be subject to your estate creditors. If you simply name a beneficiary in your life insurance policy, that money goes directly to that individual named. It would be outside of your estate. Well, I hope this helps you and answers some of the questions you might have about things that you really don't want to have them in your will. So therefore, a will should be drawn by a competent lawyer who you trust and you have dealt with in the past, perhaps. But if not, and you want to get the answers to more of your questions, then watch some more of these videos. So if you like this video, then at the end of it, simply press the subscribe button, the like button, and that way, whenever I have another video on topics such as this, you'll be notified, and then you can watch them at your leisure. Well, thank you, and hope you have a great day.